Good evening, everyone. You are welcome to the Q&A session. I hope everyone hears me. I'm a senior legal associate with TMB, and tonight I'm going to be your host. So tonight we have about 3 speakers who are going to be taking us through this week's theme. And our week's theme is employment law. We're going to be discussing several areas under the employment law. We are going to be looking at employment contracts. We're going to be looking at termination and disciplinary procedures, workplace rights, obligations. We're going to be looking at compliance and basically in relate to law. And if you have any questions, we are going to be also taking that. So you're most welcome. And our speakers tonight, we have Counsel Faith. She's our senior legal associate. And we have Daniel. He's also going to take us through. He's our researcher. And Edith. She's also a researcher with TMB Advocates. And this program is sponsored by TMB. Look, it's sponsored by Bay Investment. It's located at Freedom City Mall. And for anyone who is in need of a loan, you can visit their offices at FB 23. So starting with our program, Counsel Faith, you have some questions, I think, that came in earlier in our inboxes. And I think I'm going to maybe pick a few and you respond and we proceed. So the first one was the people want you to elaborate on the key contents or the major clauses that must be included in a contract. So between an employee and an employer. So what are those key aspects? What are those key clauses that must not miss a contract between the two parties? And the second one is looking at the human resource handbook. And someone is asking, why is it very important for an employee and employers to ensure that they adopt what we call the human resource handbook? And the last one is in relation to basically to what extent, I'm going to read it verbatim, to what extent can an employer lawfully vary the terms and conditions of employment, and when would such variations be considered illegal or detrimental to an employee? Counsel Faith, I hope you've taken note of those questions. Could you please respond to, and then we proceed? Thank you.
Hello, good evening, everyone. Anne has introduced me. I'm Faith Arinda, Senior Associate with TMB Advocates. And today we're going to be talking about employment law. Employment law is the law that governs the relationship between employers and the employees. So it sets out the rights, responsibilities, and protections that ensure workplaces are safe, they are fair, they are productive. So it's a foundation that guides how people are hired, how people are managed, how people are treated at the workplace, and how they are compensated in the world of the work environment. So the employment law is a body that regulates the entire employer. Yes, so that has been our theme week, and I felt I needed to introduce and tell people what employment law is. Yes, there is a question that was asked by Anna on asking must not go unread in the Contract Act of Uganda. So, the Contract Act of Uganda governs how agreements contracts that say lawyers, human resource officers, business owners, or managers must pay special attention to the following clauses and concepts. I know there are some people on here that are employers and some here that are employees. So this is key for you to note. One is offer and acceptance. In the Contract Act, there is a clause that talks about an offer and acceptance is basically you cannot have a valid contract without a clear offer. That is a promise to do or not to do something. I'm just giving a layman's understanding of this so that we can all be on, board and clearly understand this. Two, there must be a valid acceptance. The acceptance and communicated clearly. There must be termination of offers when an offer lapses or it's withdrawn. This is why it matters. Many contractual disputes in Uganda arise because acceptance was unclear or conditional. So, my recommendation would be that courts should enforce only agreements where the parties show clear consent. Number two is free consent. So consent must not be obtained, it must be obtained undue influence, it should not be obtained through fraud. Consent must not be obtained through misrepresentation or it matters. A contract signed under pressure or false information is voidable. Voidable means it can be it's not legal. So this protects the employees, it protects 10 parties capacity to enter into a contract and with that capacity. So a contract is only valid if somebody is of sound mind, somebody is not a minor, except for necessaries. And by minor, I mean somebody who is under the age of 18. And also, a contract is valid if it's not disqualified by law. The importance of this is that a company must ensure that the signatory has authority. Contract signed by someone without capacity may be unenforceable. Unenforceable. Four is consideration. A contract must involve something of value, that is, a payment in exchange for service or even a promise. So the consideration must be real, it must not be unlawful, and it also has to be capable of value. The importance of this is if no consideration exists, then the contract is void. And then we also have the legality of purpose. Contracts involving illegal activities or objectives are void. For example, a contract to import banned substances cannot be enforced even if both parties agreed. If you have a contract with someone, for example, to import firearms or there are cars that were banned from a certain year of manufacture, if you entered a contract with someone to import those cars, being imported into the country. Then we also have void and voidable contracts. And we need to due to maybe misrepresentation or unfairness. And that until one party cancels, the importance of this is that it helps determine the remedies and the enforceability. Then we will talk about performance of contracts. The Contract Act explains who must perform, when performance is excused, and then the effect of attempt to perform. So this protects a party who has done their part or attempted to do so, and the other person has not. And then we have breach of contract. Under the Contract Act, breach of contract it defines an anticipatory breach, an actual breach, consequences of breach, and the remedies. Remedies include damages, that is compensation, specific performance for you to perform your part of the contract, injunctions, and even rescission. So it's very important for both employers and employees to know the remedies that can help businesses to negotiate and enforce their rights in case of breach of contract. Then we have agency. Agency covers creation of agency, authority of agents, rights and responsibilities, termination of agency. So the importance of this is okay, it's relevant for companies where managers or staff act on behalf of the organization. If you have people that are working under you, they have contracts with you, and they go out there to act on behalf of the organization, they can be liable if they work out of what the company holds, or if they breach contracts on behalf of the company, they can be held liable. Yes, so those are the major key clauses that we should not miss in the Contracts Act. The second question to me was, to what extent, no, what is a human resource handbook and why it is important? A human resource handbook is basically an employee handbook. It's an official document that outlines a company's policies, the procedures, the rights and responsibilities, the workplace standards, employment rules. So basically, a human resource handbook serves as a reference guide for employees and a compliance tool for employers. So when you give somebody a contract to sign, it's very important to attach a human resource handbook, especially for companies that hire human resource experts. This is very important because it will put everybody in check, that this is how a company runs, these are our workplace standards, these are our employment rules, and it is from that the human resource handbook that will guide on whether an employee has breached their contract with their employer, whether they are following the policies, whether they are following the procedures and the workplace standards. Yes, so this employee handbook helps employers to comply with the Employment Act, the labor regulations, health and safety laws, anti-fraud and anti-harassment standards. It reduces disputes and lawsuits. So the clear rules minimize misconduct at workplaces, wrongful dismissal, unfair labor practice allegations. It also provides consistency, meaning all employees are treated the same rules. So because every employer is required to sign an employee handbook, starting from the manager, the general manager, down to the very last person, is treated the same way and treated under the same rules when it comes to the employee handbook. So it's very important for people here that have companies to have employee handbooks in place to guide. Yes, so it is also an advantage on the other side to the employees. So the employees will know their working hours, their leave entitlements, the performance expectations, the grievance channels, you know. The handbook outlines harassment-free environments, non-discrimination policies, health and safety protections, it guides your behavior. So it's a general overview on how employers must conduct themselves and also how employees must conduct themselves. My third question was, to what extent can an employer lawfully vary terms and conditions of employment? So, under the Ugandan law, employment terms cannot be changed. Um, and literally, if the change affects fundamental rights, then the employment terms cannot be changed. We have lawful variations. Employer may vary terms with the employee's consent or where the contract or handbook expressly allows it. I hope we are following. I started by saying that employment terms cannot be changed. However, they may vary if the contract permits the changes. For example, if there are policy updates, the work method has changed, the employee gives written consent, for example, agreeing to new work hours. Say you signed a contract to have an 8 to 5 job, and then you agree with your employer that you are going to start working from 8 to maybe 10 o'clock or from 2 to 10 o'clock, then you can change. Minor adjustments to reporting structure is also another reason. If the change is required by the law, for example, if there is a mandatory change by NSSF, say to the taxes, to the tax law adjustments, maybe your employer has been giving you 10%, paying for you 10% to NSSF, and NSSF has changed the policy to maybe 15%, then that change is definitely required in the contract. Then if the change does not negatively affect the employee, say for example, if you have a salary increase, better benefits, you can always sit down with your employer and change the employment terms. So, however, we also have variations that are illegal or unfair. And a variation is illegal or unlawful if it alters the fundamental terms without consent. For example, salary, you're earning 5 million shillings, and then the salary now changes to 2 million shillings. The work hours have increased from the usual 8 to 5. Your job description has changed. Your workstation has changed. Let's say you've been working at Freedom City, and now you're going to be working in Buziga. Your benefits have changed. Your leave entitlements have changed. So if all these things happen without the consent of the employee, then it's illegal and can amount to constructive dismissal on the part of the maybe general manager, the person who hires, or the human resource. Because I earlier told you that all employees have the same rules and regulations if there is a handbook, an employee handbook that they signed. Secondly, if the variation is discriminatory, the changes cannot target a specific employee based on gender, religion, tribe, marital status, disability. All that is illegal. Also, if it violates statutory standards, for example, the Employment Act sets a minimum standard that cannot be undercut. For example, the minimum rest period. What are your leave days? The maternity protections, the overtime pay. If for example, I'll talk about maternity protection leave. The maternity leave, according to the Employment Act, is 3 months. That is 90 days. Employer says no, now your leave days are going to be maybe 2 months. That is, it violates the Employment Act. Secondly, I'll also talk about the best practice for lawful variation? First of all, as an employer, consult your employees about the changes I intend to make, give reasons for the change, obtain written consent from them, give reasonable notice, and also update the contract and HR handbook if you intend to make changes to the employment terms. Anna, I hope I have exhausted that question. The three questions that you assigned to me, I hope I have exhausted them. Yes, thank you.
Yes, thank you so much, Council Faith, for that elaborative response. And I hope members have heard from the expert. And it's important that we take this. And for all the employers who are here, I think it's very clear that you cannot just wake up, one day and you change the terms of an employment contract. It becomes illegal. So it's important that we take the guidance that we have gotten. And I think it also came out very clearly, the contents of an employment or a contract. What are those must have to make that contract or employment contract valid? So I think that has come out clearly. And yes, it's very important for an employee and an employer, what guides them, the human resource manual or handbook. It's in company should have standard of operation, the SOPs, which actually guide their operation. So thank you so much, Council Faith. I think we're going to move on. There are more questions that are coming in. And Daniel, these are for you. So the question is in relation to explaining the circumstances under which an employer can be liable to compensate an employee for an injury that is caused during work. Yes, and there's another one that is also they're asking what procedure can the injured employee follow to claim that compensation. So Daniel, can you please quickly respond to this? We are running out of time, so let's try to keep time. Thank you so much.
Thank you so much, members, who have been given this question. The liability of employer to compensate the employee. Yeah, every employer who is here and employee who is attending the meeting, this is my statement I can make. As far as the law is concerned regarding this, yes, employer is liable to compensate employee for in case of any injury that may arise. However, as we move to understand this, there is what we call Employment Act, and we also have other laws. More we'll get to know on Employment Act. We have what we call Workers' Compensation Act, which is CAP 225. We also have what we call that is Occupational Safety and Health Act, that is CAP 231. Now, the Employment Act gives us the contract and the content and the behaviors of the employees, rights and duties. And then when we come to what we call the Occupational and Safety Health Act, that now gives us the condition which will be around the work, what the workers should do regarding the protection of the employees, and what the employees should do also regarding their own protection. And then now what we call Compensation Act, the Workers' Compensation Act now comes. Since we have the Employment Act that's given you the contract, we have the Occupational and Health Act, which has now allowed you to work in a good environment, protected carefully by the employer. Now, should there be any breach of this, we have what we call Workers' Compensation Act. Now, take the level of compensation. Now, this drives me to say over Workers' Compensation Act, yes, all the employer responsible for any injury caused to the employee. But however, there are things that before compensation, before holding employer responsible for the harm or for the injury. By the way, according to what we call Workers' Compensation Act, the injury can be an accident, that can be a minor injury, or can be death itself. So the determination of compensation itself depends on the nature of the injury. Is it death? Is it a minor accident? Now that will be according to the circumstance. Now it has been set by the courts for an employee to be compensated for any injury caused. There are rules that must be followed. However, before I move to that, I want to tell employers who are here the reason why you're being held responsible for the injury caused to the employee, because the law provides for your liability. And then when you look into Employment Act, when you look into Workers' Compensation Act, and then you look at Occupational and Safety Health Act, their obligation, especially when you look at Occupational and Health Safety Act under Part 3, I refer to Part 3, the responsibility, obligation, duties of the employers. The first one, which is Section 12, is very paramount. Section 12 gives the employer to protect workers. Now, that alone speaks for itself. If you're told by law that you're supposed to protect workers, meaning you should ensure every place a worker is seated or doing your work, it's safe and good for them. Now, there are people who are company directors. They should make sure that the company itself, maybe their machines, maybe their acid, ensure that your employees are protected from the harm that may result from this. That being said, it has been said by court, for one to be compensated, these are the things. First, you must have employee-employer relationship, that is employment relationship. Is there any contract? My colleague has already discussed that. Is there any contract? Are you working for this employer? Yes, true. If that is proof, we move to the second element. Maybe there was an injury which was caused. Is there injury? Yes. Was it caused? Now, the next is the injury must have been caused during the time when the employee is working, or at the time when the employee is working, or during the course of the work. It can be when the employee is driving on the road, going to do some other work and get accident. That injury, as an employer, you can't say you are out of the company. No, that is work. You are going to be liable to pay for that. It can also be when employee is walking around the company's compound, and then maybe something happens. Maybe there was some holes, and then steps on the hole, then breaks the leg. Still, you will compensate. You won't run away from such compensation. Now, all this was also set in the case. A moment. In the case, I will refer you to the case of Nsupuga versus Spencon. In that case, the court found that employer would be responsible to protect the employees, and due to the lack of protective gears, aid gears during the time, in this case, the employee was actually employed by the employer to work in the industry. What happened? The pipe burst, and the employee got some accident, and the court said, no, you are supposed to compensate this employee. Why? Because he was working, is your employee, and then got this injury at the time he was doing the work. So this has been confirmed by the court. Please, the first question is answered affirmatively. Yes, employer, you are supposed to compensate the employee. However, employee, don't just rush to be compensated. There are terms and conditions that you must first meet to be compensated. I will move to the second question. That being it is, check on the second question. Yes, what is the procedure an injured employee must follow to claim compensation? Yeah, there are procedures. You can't just ask for this compensation, but there are procedures that employee need to follow, and these procedures are set. These procedures are set under the law. They're not just from anywhere. And it is set under Workers' Compensation Act, just like I said at the beginning. Now, it runs from Section 9 to Section around 14 of the Workers' Compensation Act up to 5. Now, once an employers who are here, and the employers, attention, because this gets to both of you. First, there must be notification. Once there is an accident, an employee is supposed to report this to the employer, required by the law. And this must be done within 1 month if there is an injury. But if there is a disease which is related to the workplace, then within 3 months. Next, the notification of accident must be made by the employer to the labor officer. Yes, that's the next procedure. The other procedure is there must also be a medical examination. Now, as an employer, the injury has been reported to you. You have reported you're going to report to labor officer. You need to carry medical examination. And when you carry this medical examination, you are determining the injury and the cost is on you. But where an employee requests for his own personal doctor, then the cost goes back to the employee. Now you have to now agree after the reports. There is now you now know the injury. Now you have to agree for compensation. Now in the agreement compensation, it may happen, it may not. Where it happen, yes, you proceed. Where it does not happen, then you have to refer this to the labor officer, who will later set up a board and try to assess and come out with a solution. But where an employer, after report by employee, it doesn't react towards what the employee has said, maybe regarding the injury. The employee is under the law, under Section 13 of the Workers' Compensation Act, can now, within 21 days, can make this notice to court and get the compensation straight away from court. But where the agreement is made, we ask to look now what we call computed assessment. Now, this assessment can be done, it should be done by the doctors. Now, where the doctor gives the assessment and then there is an agreement between the employer and the employee, yeah, you can proceed as an employer to quantify and gather the money and then maybe compensate the employee. But where there is also disagreement in the computed assessment regarding the disability, then still this can be referred to a labor officer. And that is the procedure of claiming for compensation once you get injury. Thank you so much. That is how I would elaborate.
Yeah, thank you so much, Daniel, for that. That was beautiful. And members, take note. It's important that as employees, we always provide safe working environments, and it is provided within the law as Daniel has discussed, so that in the event of any accident, you will not be held liable if you've done your part as an employee. And the procedure, he clearly brought it out. Thank you so much, Daniel. So I think at this juncture, we could take 1 or 2 questions and we respond. We have more questions that are being sent into the inbox, but I think members, please, if there are any questions from what you've had to do today, or any question in relation to employment, please ask and we can proceed. Thank you. Okay, so I take it as everything is moving smoothly. Yeah, so I think we'll move on. We have some more questions that are coming in our inbox, and yeah, so I think yeah, we'll move on to people want to understand the difference between the word termination, dismissal, and summary dismissal. Sometimes people mix that, so I think they want to understand that, and they also want to understand how an employer can minimize the risk of unfair dismissal and ensuring that they comply with the Employment Act. And then they also want to know, in the event of an unfair termination, what remedy can an employee seek? So, Edith, are you there? Please, can you respond to this? Hello? Yes, please. Can you speak up? And please, can we try and be fast? We are running out of time. We apologize. We started a few minutes late. So let's try to speed up a bit. Thank you so much. Hello, Edith, are you there? Are you there? Okay, it seems Edith is having some network issues, but we can move on. Edith? Hello? Yes, please, can you unmute? We can't hear you. Hello?
I think also I can take up that. Colleague is not available.
Yes, please. Daniel?
Thank you so
Yes,
much.
please. Can you take it up? And as you are taking that up, can you also respond to maybe the differences between working hours, rest periods, overtime, and the payment of wages, and what do they mean by leave? And are there different types of leave? And can you summarize that in like 3 to 5 minutes, if possible? Thank you so much.
I would ideally start with termination. Termination, in a simple way, means ending the contract. Ending the contract. Now, under Employment Act, when we look through Employment Act speaks under Section 64, and it's speaking tells us how contract can be terminated. And one of the ways that contract can be terminated is when the contract comes to an end. My colleague discussed the terms and conditions in a contract, like a contract of employment. So there are there is a period within which the contract may end. Fixed contract has ended, maybe probational contract has come to an end. So that is a way how termination can happen. That is subject to Section 64. And then when we look into what we call definitely dismissal. Now, dismissal is provided for under Section 65, and also we find it under second schedule. But this is the meaning: you are being maybe told by the employer that, please, from today you're no longer part of this work. It's not ending legally as in contract, get the difference, but somebody is telling you, I can't continue with you, and there is a reason.
Everybody want to
Now,
crown.
under Section 65 of
Nobody want to score.
Act Cap 226,
Ni muto
that
oyagala mbere ne
dismissal
muto
can
oyagala
only
mbere
happen
ne
on two
business.
grounds. First, poor performance and misconduct. That is it.
Nsinga nekozesa
And
mwana
then
kyogamba tata
we move to summary dismissal. Summary dismissal occurs when there is a
His pro opponent. Tonight he's facing, I would say, his toughest challenger. Abdullah Mace. He's skilled. He's charismatic.
He's under the contract of employment. Should you go and fundamentally breach it, that can lead to
He's quick.
seconds under the contract of what happens that when they're dismissing, should you go and this fundamentally breach it, that can lead to summary dismissal. And now summary dismissal is provided under second schedule. Mean you are going to be paid. What happens that when they're dismissing you on this, please you are not. Now that is as brief as I will discuss termination, dismissal, and summary dismissal. Now discuss how employee can minimize the risk of unfair dismissal while ensuring compliance. The simplest answer is follow the procedure under Section 65 which requires fair hearing before dismissal of the employee. That is the simplest answer. But now to substantiate that, I would refer you to the case of Okulunyonyo or Julius versus Kampala Serena Hotel, labor dispute number 12 of 2017. In this case, the employee had worked with Serena Hotel for over 15 years, I think, and then he claimed that he worked faithfully, he did everything well as a technician, electric technician, but still he was dismissed from the work. His argument was that he was not accorded time for hearing, he was not given notice, he was not allowed to have legal representation. What does the court say? The court said, despite the fact that you can terminate, you can dismiss, you must follow the procedure of fair hearing. And that's why my colleague in her explanation talked about what we call employee book or employee book. That book provides for policies, procedures of disciplinary move. So if those procedures are clearly followed by the employer, then the employer has minimized such circumstances. Now, the next question is, what are then the remedies? What are then the remedies? Now, under Employment Act, once you have been unfairly terminated, you can be compensated. Now, this depends on the circumstances. You can be given severance payment. You can be also given damages. Now, this depends on the circumstances because all these are provided for differently under Employment Act, then under Workers' Compensation Act, and then Occupational Safety and Health Act. I think this is how I would discuss this question. Thank you so much.
Yes, thank you so much, Daniel, for that elaborative response. And members, I hope you've taken note the differences between the three. Often we confuse them, but they're all different. So take note, and as employers, always give your employee a chance to explain themselves so that if it's something that is solvable, it can be solved. But if the hearing is done and it is still determined that that employee should be terminated or dismissed, then the law will protect you. So thank you so much. I think the next we have some more questions. We are almost using up our time, but we can conclude this in the next few minutes. So this goes to Council Faith. People want to know what it means by leave. Do employees have a right to leave? And are there different types of leave? Can you please explain that briefly? And there's another one also that has just come in. Someone is asking what is the difference between working hours, rest periods, overtime, and payment of wages. So they want to understand that. So can you briefly elaborate on that? Thank you so much.
Yes, thank you, Council Anna. Yes, employers are entitled to leave days. I'll start by that. So the question is explain the statutory provisions governing working hours, rest periods, overtime, and payment of wages. Okay. We have statutory provisions that govern working hours, rest periods, and overtime, and payment of wages. So the Employment Act sets the general rule on working hours. The normal working hours are typically 8 hours per day. That is, you hear people saying 8 to 5. That is a typical 8 hours per day. 48 hours per week, if you are to do the math. So where the sector or the contract specifies otherwise, it must remain reasonable and not exploitative. That means that these working hours may change based on the sector you're working in. For example, if you're in the health sector and you are required to work an overtime, if you are in construction and you're required to work an overtime, or even if your contract specifies otherwise. Could be less, it could be more hours. So the employer and employee may agree on different working arrangements so long as they comply with the Act. Shift work and night work are allowed, but they must ensure proper rest and safety. Say the people who work in the night, the people, usually those are for people who work in the night. You must ensure that people have proper rest during the day and even their safety. For example, if there are people who are in construction and they're building in the night, you must ensure that they are safe. Rest periods. The law requires adequate rest for workers. That is daily rest, weekly rest, and even public holidays. Under daily rest, employees must have a break during a continuous working hours, normally like an hour for meals. And after 5 consecutive hours of work, someone should be able to take a bathroom break. They should be able to go out and get some air. Employees here, give your employees a break. And by a break, I mean during a continuous working hour of 8 to 5. You don't expect someone to sit at their desk from 8 to 5 and even have their meal at the desk. Okay, there's some workplaces that don't have a dining space, but if somebody feels they need to step out for lunch, give them that time, an hour maybe, to go out and have a meal. And for example, count from 8 to 5, someone may stand up and go take a phone call or, do a small errand and come back to work. So you need to give your employees a break. Number 2, weekly rest. At least 24 consecutive hours of rest in every week, really. Typically falls on a Sunday, but it can be on any agreed day. Yeah. Then for public holidays, employees are entitled to public holidays. And I will emphasize that paid public holidays. So when you are calculating how many days your employee has worked in the month, don't say because you didn't work on this day that fell on a public holiday, I don't count that payment. No, that is not allowed. You are supposed to pay your employees even for the days they've not worked that fall on a public holiday. And also, if they work on a public holiday, it becomes overtime. That is, you've requested your employee to come in on Independence Day. You must compensate their overtime as an employer. Employers, I'm not attacking you. This is just what the law provides. Yes, so what is overtime? Overtime refers to hours worked beyond normal working hours. Say in your contract says 8 to 5 and then you request someone to stay in up to 8 p.m. You should be able to compensate for their overtime. What are the conditions for overtime? Overtime must be agreed to by the employee. That is explicitly, or if it is written in their contract. There are certain categories of workers who may, be exempt from that overtime, like the management staff, managers here. It is just, I'll not call it courtesy. It just comes with your job that maybe you're the one who is going to close the office at maybe 7 p.m. or ensure everything is okay. Overtime may be exempt for you. The Act provides that employees must pay a higher rate for overtime. The common practice is usually, employees here are going to attack me, but you're supposed to give about like 150% of an hourly wage for normal overtime, 200% for work done on a rest day or a public holiday. So these percentages are not in the act itself. They're just derived from the wage orders and, the established practice, you clear their transport, their lunch, the time. So when you do the math, it comes to a higher percentage. So employees here, please know your rights as you are negotiating for overtime. Overtime should not compromise the employee's health or safety. Say someone has been working from Monday to Saturday to Friday. You want them to come on a Saturday from 8 to 5 and also Sunday from 8 to 5. When do you think your employee is going to rest? You are playing with their health. You're not putting their health into consideration. Are they safe? And then you expect them to come to work on a Monday morning by 8 a.m. Surely, that should, even if they are paying you, it should not compromise with your health. Excessive overtime without rest will be considered as forced labor, which is illegal. That is, you're working from Sunday to Sunday, even if you are being paid overtime. You're literally on the job. That is considered as forced labor because you are entitled to rest. Okay, I'll talk about payment of wages. Wages must be paid in the legal tender. Our legal tender is cash, check, or even a bank transfer. Now mobile money as well is considered as a legal tender. The wage period, wages must be paid at regular intervals, not exceeding 1 month. If you exceed the month, then you are delaying payment for your employee. The deductions, the permitted deductions include pay as you earn, that is a tax, NSSF contributions, maybe on some are authorized deductions, say loan repayments, people who get salary loans, yeah. Even a court order can be can permit your employer to deduct your salary. So illegal deductions are prohibited. Note that I have mentioned 4 permitted deductions: pay as you earn, NSSF contributions, court orders, and loan repayments. So anything outside that is an illegal deduction. Say you've come late to work, so we are going to cut your salary. That is illegal and it is prohibited. Say you have broken a cup in office and your salary is deducted, that is prohibited. However, your employer you can repay it, but it shouldn't be deducted from your salary. Your salary should be given to you in full first, and then you can pay for the damages that you have incurred. Employees are, the employees who are performing the same work should receive equal pay for equal value. So there shouldn't be discrimination based on the gender, based on the religion, based on disability, etc. Because there are 2 people doing the same job, but one is a pregnant woman and maybe she is, not working as much, and you feel the need to underpay her, that is prohibited. In organizations where there may be Muslims, for example, and a Catholic has entered into the organization and you feel she should be paid less, that is illegal. So employers should also issue pay slips to their workers. And under the pay slips, it should indicate your basic salary, your allowances, your deductions, and your net pay. Usually these things are in your contract. Yes. So the importance of itemizing your pay statement, indicating all the things that they're paying for, it promotes transparency and also it protects the employee, because the employee can come up with their pay slip or with their contract and say, you did not give me my allowance for this? We agreed on this net pay. Why am I earning this? So employees here, you need to talk to encourage your employers to, have contracts signed with you, and also issue you pay slips every month. Okay. The second question was discuss the law around the right to leave and the types of leave. So the Employment Act gives employees several types of leave. We have an annual leave. Annual leave is at least 21 working days of paid annual leave after 12 months of continuous service. By 12 months of continuous service, I mean after you've been on job for a year, you are entitled to 21 working days of paid annual leave. The leave pay must be fully paid. Leave may be taken in parts if the employee agrees. For example, there are some people who will say, I want all my 21 days at once. They can be given to you. That is almost a month of no work, but paid. There are those who will say, I want a week off, I want a day off, I want 2 weeks off, or this. They can be deducted from your 21 days throughout the year. Yes. Then we also have part-time. For part-time workers, we have they're called prorated based. They're based on the days worked. You can agree with your employee for your leave days based on how your part-time timetable runs. We also have sick leave. The Employment Act stipulates that employees are entitled 30 days of paid sick leave per year. And that is after 2 months of continuous service. Say you've worked in an organization for over 2 months, you are entitled to 30 days of paid sick leave per year. So that is a month. You can say, today I'm feeling sick, and then you don't come to work. Or you can say, maybe I've been on bed rest for a month, so you'll not come to work. So the sick pay should be paid at the full wage rate. And then most importantly, the maternity leave. Maternity leave is 90 days. That is approximately about 12 weeks of fully paid maternity leave. And please note that must include 4 weeks before childbirth. The conditions are that the employee must notify the employer and provide medical evidence that I am giving birth in this month, and you apply for your leave days earlier. Then it is not right for the employer to dismiss someone based on pregnancy. The law prohibits this. It's very legal. Easily challenge that dismissal in court, and that would be another direction. Fathers, you are entitled to paternity leave. Your paternity leave is 4 working days of fully paid. It's per year, and that only happens after every 6 months of continuous employment. So if you've been at a job for over 6 months, you're free to apply for paternity leave of 4 days. Then we also have a bereavement leave. It's called a special leave that is granted in the event of death of a spouse, of a child, of a parent, or a close relative. So this is usually paid through the number of days, but this may depend on contract or a company policy. There is no stipulated period of time or the number of days in the law. That it will be determined under your contract or your company policy. So the law it generally recognizes this special bereavement leave as reasonable leave necessary for family responsibilities. at your workplace, you're not a slave. You have a family, you have things running for you. So you are entitled to these things. Some of you fear to tell your employer that I've lost someone, a close relative, because you fear that maybe that day you've not worked is going to be deducted, that the payment will be deducted from your salary. You are entitled to that, of course, with proper evidence. Some people kill their relatives almost every month. I've lost someone, and you don't show up at work. That's wrong. You need to provide your employer with clear information and evidence. Then we have public holidays. These are also considered leave days. You're entitled to paid public holidays. And as I earlier discussed, if you work on a public holiday, you must receive your overtime or be granted an additional rest day. You negotiate with your employer that maybe you've called me to work on a Sunday. Can I rest the next day, Monday, and come to work on Tuesday? Or negotiate maybe an overtime pay, something like that. Then we also have study leave or examination leave. So we're working with employees who are studying, who are pursuing further studies. And that should be relevant to your job, by the way. You are entitled to study leave. And this is not explicitly detailed in the Act, but many employers provide it via policy, company policy, or even contract, depending on how you negotiate your contract. Then we also have compassionate leave. Compassionate leave allows time off for family emergencies, personal like you have a crisis. This is not also fixed by the law, but it is often found in internal HR policies, like I earlier discussed. Every company needs to have an HR policy that mitigates such small emergencies. Then I'll also talk about the unpaid leave. We've been saying all the leave is paid and what, but there is also unpaid leave. Unpaid leave is granted on request of the employee when they have exhausted their paid leave. You've exhausted your 21 days, but you want to go on leave maybe for another, 21 days. You will not be paid. Okay. This must be agreed mutually and cannot be forced on by the employee. Yes, so I have exhausted that question, Anna, and I hand over back to you.
All right, Faith, thank you so much for that. That was so elaborative, and I think we have far spent our time. But there's a question that came from Elvis, and this is to you, Faith. Elvis was asking, what if they worked overtime, and that overtime is compensated by a day off? Is that acceptable? Can you briefly respond to that? And Daniel, you can come in and we finalize with there's a question on what does it mean for under the Employment Act, what we term vicarious liability. So when Faith responds to that question, can you just come and we conclude? Can we do this in 5 minutes? Thank you so much.
Yes, I will answer that question. I've just discussed that you can negotiate with your employer about the overtime. If for example you've come to work on a Sunday and you say maybe instead of paying me, can I rest the next day? That is solely about it depends on how you've decided to negotiate with your employer. If your employer agrees to it, then you can definitely have your rest day on Monday in exchange for the payment that you would be expecting for overtime. Yes, thank you. Over to you, Daniel.
Thank you so much. I'll be very quick to answer this question regarding vicarious liability. Now, employers and employees who are available here, that what is termed as vicarious liability is liability of someone who has as an employer, I beg your pardon, it's a liability of the employer for what he or she has not done, but that which his or her employee has done. Let me simplify. Now, this is not expressly provided in the Employment Act, but it has been developed by court. And in its definition, we shall find that when somebody asks you of what is called vicarious liability, you would only define it as a liability that arises from a relationship that exists between employee and employer. And this is when an employer is held liable for an action of their employees. I'm going to give two examples. First, I want to use the security companies. In Kampala, we have very many companies that deal with security services. Now, you are an executive director or CEO whatsoever, as long as you are that part of the company and you take the responsibility of managing it. And then you have employed all these employees who are holding guns in their hands to go and take care of every places wherever they're going to be there. Now remember, whatsoever act they are going to do, it's the act of the employer. Mark it clear. Whatsoever act your employee is going to do, where you've employed them to do the work, it is your act. He who act through another act for himself. That is the principle, and that's why we look into the case which has been developed in Uganda, which is called Monge versus Attorney General. It is a case of 1967. That case says for an employer to be held for the act of their employee, these are the principles. First, we must establish that there must have been relationship that exists between them that shows that this is really an employee and this is the employer. Yes, you've employed Mr. Daniel. I say, yes, Mr. Daniel was taking care of this place. Yes, this happened. You are held responsible for what Daniel has done. Now, the next element is the tort must be committed by the employee. That act which you are going to complain of against you as an employer, it must be such act that your employer really did it. If they said there was shooting at that time, you establish, was that shooting by my employee? If that is established, that element is really complete. And then it must be in the course of business. Let me assume that as a company, a security company, of course, offering security services, and then your employee sneaks outside the time for work with the gun, by the way, for your information, with the gun, and then goes around the city and shoots people there. There you can clearly go outside and defend yourself. You say it wasn't at the time of the business, I had not sent him for service. So these are the elements that you need to establish. And then the burden of proof will lie squarely on you as required under the Evidence Act, Section 101, that he who alleges must prove. So it will lay squarely on the plaintiff who is claiming, on the person who is claiming that your employee maybe shot somebody somewhere, and then you as an employer, you're supposed to be responsible for the shooting of the employee. They must prove that exactly that employee did the work or did the killing, committed that tort. I think that is a brief discussion anyway. In summary, for employer to be held responsible for any act done, maybe a crime, maybe tort, something like that, that the employer is responsible, you must first establish the existence that shows that these people are both either employee or employers who are actually relating in what we call employment relationship. And then you must also say that yes, he shot this person, it is your employee. You must also say yes, he did this when he was taking care of this petrol station. When that is done, it's done. Employer, you're held responsible. Thank you so much. That is as brief as I would give the discussion. Thank you.
All right. Thank you so much, Daniel. I think that brings us to an end of this Q&A session. I would like to again extend my appreciation to Council Faith for those elaborative responses that you gave. I know we have been enlightened. We have all learned something from today. Daniel, thank you so much. Ashri, our IT, thank you so much. And for everyone who attended and participated in one way or another, we appreciate you. And we are grateful again. This program was sponsored by Bay Investments. And see you again next week, same time. Thank you so much. Have a blessed evening.